I'm starting the live streaming now. Okay. Councillor, are we all ready?
Yes, thank you, sir.
Thank you. Breathable.
It's a bit more me.
All rise. Yes, Ms. Morris.
Lord, may I just answer the court's question this morning, which is what's going to happen in terms of the review processes which are being
Yes.
in place. The position is that they will all remain in place until the CAS review says that something different needs to be done. So they're all there in place until the CAS review, having looked at everything, makes a decision about what ought to be there.
Thank you.
So just, I think, two and a half authorities before we get to the grounds. First of all, why You've got that in the main bundle of authorities at tab 11.
And a page number?
339.
339. And this is why.
Yes. So this is the decision of the Supreme Court relying and describing as valuable what my Lady Justice King said in Briggs. Although it will obviously be very familiar to you in some ways, I'd be grateful if you might read it briefly.
So this is Lady Black's judgment.
Exactly.
Yes.
And could I ask you to turn to paragraph 58? And Lady Black quotes what was said in Briggs. And again, we say that these points chime in the circumstances of this case. And perhaps I should say that we showed the court below rewind, but it isn't addressed at all in its judgment. So this is what was said in Briggs.
Which paragraph are you at?
It's paragraph 58, page 363 of the bundle pagination, page 1002 of the internal pagination. So in reality, virtually all of these traumatic decisions are made by agreement between the families and the treating teams of the person involved. To suggest that every case should go before a judge, even where all concerned are in accord as to what was in the best interest of the patient, would not only be an unnecessary pressure on the overstretched resources of the NHS trusts and add to the burden on the courts, but, most importantly, would greatly add to the strain on the families having to face these unimaginably distressing decisions. In my judgment, the practice directive provides valuable procedural guidance. It shouldn't be interpreted as introducing a requirement that all cases where a decision is to be made about the withdrawal of CNNH must come before a court. And then further at paragraph 59 indented, if the medical treatment proposed is not in dispute, then regardless of whether it involves the withdrawal of a treatment for a person who is minimally conscious or in a PBS, it's a decision as to what treatment is in P's best interest that can be taken by the treating doctors, who then have immunity pursuant to Section 5 of the Mental Capacity Act. If there is a dispute in relation to medical treatment to an incapacitated person, and specifically where there's doubt as to whether it should be withdrawn, then the matter should be referred to the court for personal welfare declaration. And then I'd also ask the court to look, please, at paragraph 115, because it's another potent statement from, in this case, the Supreme Court. So it's page 378 of the bundle, internal page 1017, paragraph 115. It remains to stand back from this intense focus upon the law in order to consider the issue in its wider setting. In so doing, it's necessary to exercise the restraint that is required of a court when it ventures into areas of social and ethical uncertainty, and especially when it does so in the abstract, setting out views which will be of general application, as is necessarily so in this case, rather than resolving a clearly defined issue of law or fact that has arisen between the litigants appearing before it. And then there's a repetition of what was said in Bland, and it notes this: how frequently doctors have to make decisions which may affect the continued survival of their patients, and how experienced they are in this respect. Judges have also developed experience in dealing with life and death decisions. This experience of a different sort from that of the medical team, which actually treats the patient, and of the professional bodies responsible for regulating and guiding them. And this limitation must be recognised and taken into account. It's been a particular assistance to have from the written submissions of the interveners an insight into the practicalities of caring for patients who are critically ill, and also some idea of the large number of patients who might be affected in some way by the decision in the incident case. And then also paragraph 119, which is bundle page 380, internal pagination 1019. In any event, I have difficulty in accepting that there are readily apparent and watertight categories of patient with PDOC patients clearly differentiated from, say, patients with a degenerative neurological condition required for the PDOC patients, but not for them. And then at the end of that paragraph, doctors will often have difficult diagnoses to make. Reaching a prognosis may be challenging, and the evaluation of the patient's best interest may not be straightforward. All these tasks may call for considerable professional skill and individual judgment. And there's also an observation which I invite the court to paragraph 120, although no doubt the court has its own understanding of this, which is to obtain a decision from the court speedily, giving the example of a case which was concluded within 8 weeks, I fear is an over-optimistic view of the situation. And you'll see that one of the positions advanced by respondents is that in these cases, one could easily achieve a resolution within the family division. We would say that what is said there is a more accurate reflection of the true position. And then I'd ask the court to note again at paragraph 121 a repetition of the acknowledgement of the very great strain on families facing acutely distressing decisions. And the conclusion this: in a case where all the proper procedures have been observed and there is no doubt about what is in the best interest of the patient, there is much to be said for enabling the family and the patient to spend their last days together without the burden and distraction and possibly expense of court proceedings. And I'd also draw the court's attention to the last sentence of that paragraph. And we say again, it might chime here. It's not inconceivable that it might, as the BMA suggests, and this is in position of an application to the court requirement, generate a reluctance in some cases to start treatment or to stop treatment because of the procedures attending its withdrawal. And then I'd also ask the court to look at 124, just before E. The process is the subject of proper professional guidance covering vitally important matters such as the involvement of the decision-making process of a doctor with specialist knowledge of prolonged disorders of consciousness and the obtaining of a second opinion from a senior independent clinician with no prior involvement. And then at the bottom of that paragraph, just by G, the interests of patients and their families are safeguarded as far as possible against errors in diagnosis and evaluation, premature decisions, and local variations of practice. Finally, at 126, I don't consider it's been established that the common law or the convention, in combination or separately, give rise to a mandatory requirement to involve the court to decide upon the best interest of every patient with a prolonged disorder of consciousness before artificial nutrition and hydration can be withdrawn. If the provisions of the legislation are followed and the relevant guidance observed, and if there's agreement of what is in the best interest of the patient may be treated in accordance with that agreement without application to the court. So the final legal issue is this issue of evidence, and I'm aware that my Lord Justice Burnett has the rules of evidence in judicial review very firmly in mind. I wonder if I can just invite the court's attention to the Law Society case, which is at tab 10 of the bundle, page 302. And it's a judgment of Mrs. Justice Cara Denmore sitting with Lord Justice Leggett. And the head note provides us with a convenient digest of the propositions. Essentially, they're these: that there's seldom expert evidence in judicial review proceedings because it's rare for it to be reasonably required to resolve those proceedings. And of course, you'll recall that that reasonable requirement is what's provided for in the CPR Part 35. Now, what Mr. Justice Carr said is it could be said to be required if what is contended is that the decision challenged is irrational by reasons of a technical error that is not discernible by law unless it's pointed out by someone with technical expertise, so that once pointed out, it is incontrovertible. However, if that expert evidence is contradicted by a rational opinion of another expert, then it's not incontrovertible, in which case it's not reasonably required. And so, I mean, it's perhaps by a process of logic one arrives at the proposition that my Lord advanced this morning about the need to essentially accept the evidence of defendants in judicial review.
Well, I think the House of Lords said so about 25 years ago,
Exactly.
and it's been applied countless times since.
Exactly, it's not news. But perhaps also procedurally, it's worth observing. And again, I'm just going to articulate the proposition and give you the note. It's paragraphs 36 following, but particularly paragraph 44. If you do want to rely on expert evidence, then you should make your application at the earliest possible opportunity. And that application should be resolved before or at the start of the hearing. The Lords, we've also obviously mentioned the Ancarian reefer, which is probably engraved on everyone's heart. But of course we say it's important here because it emphasises the need for experts to rise above the exigencies of litigation. And of course that's reflected in the practice direction, which is the need to provide a CV and to explain that you understand your duty to the court. And of course, in particular, that duty to the court was signally missing in the evidence which was accepted by the court in this case. And indeed, you will be able to read for yourselves the distinctly partisan tone in which the experts relied upon by the respondents expressed themselves. That's what I have to say about the law. So I'm hoping I can canter through the grounds quite quickly. Ground one is the departure from Gillick. Gillick says competence is a question of fact, not law. It depends on the child and the treatment, and we shouldn't be engaged in generalised exclusions. There shouldn't be any lines drawn unless they're being drawn by Parliament. The rights of children are best protected by the regulatory scheme and doctors, not the court. And we know, looking both at Gillick and subsequent cases, that you shouldn't be singling out any treatment as an exception for Gillick because it's novel or because it's sensitive. Gillick is good for everything. So if we apply those propositions to the judgment, and you have the judgment in the core bundle, it starts at page 73. And so if you turn then to page 76 at the end of the first paragraph on that page, we say this is where the court first goes wrong and says this: the sole legal issue in the case is the circumstances in which a child or young person may be competent to give valid consent to treatment in law and the process by which consent to the treatment is obtained. And pausing there, it's never a legal issue whether a child or a young person is competent.
So where did they say that? I've lost it. Did you say 76?
Page 76.
Oh, sorry.
Top
No,
paragraph.
it's in the. You're referring to the judgment of the divisional court in this case.
Yes, I do apologise.
Yeah, no, I know that. My fault.
Did you say paragraph 11?
9.
Ah, that's good.
Gosh, I've really fluffed that one.
Do you want to start this little
Let's
bit of your
start
submission again?
So we're in the judgment, which is in the core bundle, and paragraph 9 of the judgment starts on page 75. If we turn over the page to the end of paragraph 9, what the court says is the sole legal issue in the case is the circumstances in which a child or young person may be competent to give valid consent to treatment in law. We say that sentence is problematic because we know from Gillick and all the subsequent cases that the question of whether a child is competent is a question of fact, and indeed a highly fact-sensitive question. It's not a question of law. Then if you also go on to paragraph 74, and the last sentence of paragraph 74. This is really the development of this error in their reasoning, because having told themselves that they can decide in the abstract, they then ask themselves what's material, and they say this: the degree to which the treatment is experimental and has as yet an unknown impact does go to the critical issue of whether a young person can have sufficient understanding of the risks and benefits to be able lawfully consent to that treatment. So that sentence has a number of problems. First of all, there is an attempt to decide in the abstract whether any young person can have understanding, and that is something which we have been repeatedly told cannot and should not be done. And so that is a fundamental flaw. But this, one also must ask, what does this sentence mean? Does it mean that the treatment is so experimental and has such an unknown impact that no one can ever consent? And I suppose by implication, perhaps, is it saying, well, we're in the territory of RER and REW? But we know from AB that that isn't the answer, because Mrs. Justice Lieven accepted that, however experimental or however unknown the impacts, a parent was capable of understanding. So it can't mean that this treatment is so experimental and its impacts are so unknown that it can never be consented to. Then it must mean, well, consent can only be given on the basis that its experimental character or its unknown impacts are explained and appreciated. And of course, the court found that they were explained. And the question of whether they're appreciated or understood is a question of fact in every case. Then also, if I can give you one other example of the failure to deal with Gillick properly, if you turn on to paragraph 127, and that's page 105 of the bundle. In fact, if one looks at the preceding two paragraphs, so 125, of course, says the following principles can be derived from the cases. 126. The question as to whether a person under the age of 16 is Gillick competent to make the relevant decision will depend on the nature of the treatment proposed as well as that person's individual characteristics. Absolutely correct. Paragraph 127, there's then...
Well, just going on, the assessment is necessarily an individual one, so that emphasises what you submit is the correct approach.
Exactly, 100% correct up to that point. But then, materially in paragraph 27, we get the first of a number of problematic howevers. The court correctly directs itself, and then it says, that doesn't mean it is not possible for the court to draw some lines. And of course, that is precisely what the House of Lords said should be done only by Parliament. My Lord, those are a number of examples of the ways in which the reasoning of the court failed to adhere to the propositions of Gillick, and in so doing justified singling out one treatment from all others, entirely contrary to law that had been established for decades. And we know that the court had tested this question of whether something could be singled out on a number of occasions, and perhaps most materially in the Axon case, where it grappled with the novelty and the sensitivity, delicacy, complexity of a decision, but maintained the line that Gillick was the beginning and the end of the law. And we say that that really was the first and course, it is one which sounded in the declaration, which is the subject of this, because the declaration, with its reference to the paragraph 138 factors, is generalised and isn't sensitive to the individualities. And one can test that with various examples. A patient who's infertile, for example, or a patient who carries a genetic disorder so that it would be most unwise for them to have children. One can think of a host of examples where the weighing of factors will be different depending on the character of the patient and the treatment contemplated. And that's why that drawing up of factors does violence to Gillick. Ground 2. This relates to the importing of Mental Capacity Act principles, and most materially the approach taken by Mr. Justice Cobb in S. There are perhaps a couple of other points to make about this. I've shown you Sir James Mundy doubting that approach, but also I would add for your note that you have in our skeleton in the bundle, it's paragraph 39 of our skeleton, a reference to a warning from Mr. Justice Hayden, President of the Family Division, against the use of artificial generalised lists in the context of mental capacity cases. But as I explained, the fundamental flaw by taking the approach of Mr. Justice Cobb was assuming that the court could formulate without direct assistance from clinicians a list of factors. So we say that any generalised list is wrong because of Gillick, and because it's acutely insensitive to individual characteristics. But if there were ever a case for a list, it should be a list devised by clinicians and not by judges, and certainly not by judges without specific advice on that topic from clinicians. The third ground arises from the deviations from the Family Law Reform Act. You'll recall that what the Leahy Committee said was that the law should be simple and clear. And of course, that is what the Family Law Reform Act gives us, a simple and clear proposition. But again, in this case, the court below adopted the same style of reasoning, acknowledging the Family Law Reform Act, but using that word, however, to distance itself from its force. And so I'd invite your attention to parts of the judgment that we looked at right at the beginning of the day. And so page 109 of the full bundle. So that's where the court, at paragraph 146, acknowledges the presumption of capacity in the Family Law Reform Act. And indeed, at the end of that paragraph says, we do not consider that the court can somehow adopt an intrusive jurisdiction in relation to one form of clinical intervention for which no clear legal basis has been established. And if you go to the next paragraph, 147, same mode of reasoning. However, we recognise that in the light of the evidence that has emerged and the terms of this judgment, clinicians may well consider. And so what we've said in our skeleton, we maintain it there, is that there is a deviation from or an undermining of a clear statutory proposition by sowing this seed of doubt in the mind of clinicians. And indeed that seed of doubt morphs, as I showed you this morning, towards the end of the judgment into more than sowing and sowing, but a statement that they should make an application to the court. Now, my lords, we say whatever the rights and wrongs of giving guidance, no guidance should be given by a court which countermands or undermines such a clear statement of Parliament to law. And you can see a similar problem if one stays on page 109, paragraph 149. There's a statement that it is the court who should determine whether it is in the child's best interests. And then, yes, as I've said, the conclusion of the reasoning is at paragraph 152 over the page, and I showed you this morning, it's the conclusion. So we go from a may well regard to a court, authorisation of the court should be sought. And we say that cannot be consistent with the Family Law Reform Act. Now, one attempt to justify that exception is on the basis of the cases of R and W, which I showed you before, the short adjournment, the judgments of Lord Donaldson. Of course, you'll recall that those cases were concerned with life-saving treatment or potentially severe injury. And what the court was talking about was allowing a child to reach their 18th birthday. So we're talking about survival or something near to survival. The other difficulty, we say, which we rely upon in relation to this ground, is not only that there was this undermining of a clear piece of legislation, but it was done in the fashion of giving what was being described as guidance. And we say, for the reasons that we've just looked at in the case of Y, that's not something that the court should be engaged in. Now, I turn next to the next...
Sorry, Ms. Myers, do you say that the giving of general guidance actually has the effect of deciding between competing expert evidence? Because if you're giving guidance, you've had to get it from somewhere, you get it from experts, and you may like one side or the other, but there's been in a judicial review case no testing of that evidence. So is that a vice that you point to?
Certainly, my lord, and it's extremely helpful, and it's a parallel, isn't it, with our point about Mr. Justice Cobb's decision. You know, he's well able to set out a list of criteria whether those criteria are legal. If the court is minded to set out a list of criteria of general application, then it ought to do that having warned the professional bodies concerned and allowed them to make submissions about it. But of course, as we know from the Law Society, that might put the court in an impossible position, being asked to adjudicate between different views of experts as to what are the relevant factors. And of course, we say that there's a further difficulty in the list of factors that were devised in this case, because they were devised rejecting the evidence of the appellants and the international clinical guidelines upon which they relied in fulfilment of a service specification drawn up by NHS England in pursuance of its statutory obligation.
So just to finish this off, does the service specification and the W path guidance and the society guidance that showed us, because it's all of a piece with what you say you follow, is in the nature of the respondent's case that the court can properly take into account as being the factual position.
Yes, well, in fact, all we are empowered to do, viewed through a public law lens, is that which we're commissioned to do by NHS England. So that's the service specification. You can see the service specification lays down with extraordinary precision what we can, can't, should, shouldn't do. That is expressly relies upon those clinical guidelines, and our clinicians also say in their evidence that that's what we work to. And so, my lord, yes, it's part of a wide framework. And again, if one thinks about the phraseology of some of the other cases when they say, well, if a doctor started to do something very different from this, then there are all kinds of regulatory consequences, either institutional regulatory consequences or individual regulatory consequences. And that's a theme from Gillick onwards, that if you start to do something that is significantly different from the mainstream, then you need to think about that very carefully. And that's perhaps the curiosity in this case, that which is done by my client is firmly within the medical mainstream. So turning then to the...
So just to follow that through, in Gillick terms, I mean, Gillick in the end was also concerned with the circumstances in which a policy, in that case, a fairly simple policy, written policy of the NHS, could be considered unlawful. And so the set of reasoning was, first step, can it be lawful for a child to give the consent for contraception and so forth? In Gillick, the answer by a majority was yes, well, it is possible for a child to give consent. But then the next step was, well, now looking at the policy, is the policy capable of being operated lawfully? In other words, can the doctors deal with consent properly? And the answer to that was yes. And that was the end of it, so far as Gillick was concerned. Have I got that
my
right?
lord, yes. And of course, the court below was entirely satisfied with the consent process. So the second ground which attacked that failed. So there is no live criticism of the consent process, either of my client, which was directly challenged, or of the consent process of the Leeds and UCLH.
Well, and the curiosity is that the court also accepted that a child can give consent. What it then did was to specify the circumstances in which that consent would be valid, which I appreciate you seek to overturn. But I'm increasingly puzzled about precisely what it is under challenge in this case.
Well,
both below and now.
Well, Lord, obviously below, what was said was, the phrase that was used was policy and practice.
Yes.
And we made the point in our pleadings and so on, which is you are challenging a policy or practice which is to make a referral to another pair of NHS bodies for them to make a further clinical decision in the exercise of their clinical judgment. We said that's what's attacked. And that policy or practice which was performed or implemented by my client was performed or implemented solely pursuant to a service specification imposed upon it by NHS England. So, and my lord, that's the other parallel with Gillick, which is that we took the trouble to show the court the statutory origin of that service specification in the same way that the court in Gillick looked at the statutory obligation and that origin of that policy. But, my Lord, obviously we contended right at the outset this is a case for which permission should never have been granted because we were simply not in judicial review territory. But obviously
So
we didn't succeed.
in paragraph 19 of the judgment below, we have, as this case is brought by way of judicial review of the GIDS policy and practice, it's the context of not going into the facts of individual cases that the observation is made. So the policy and practice in your submission is of the Tavistock to make referrals to the other NHS bodies.
Exactly, and this was all teased out in the pleadings.
Well, that's why I'm asking, because it gets a little bit lost in the detail, the very, very useful detail that we see in the judgment.
My Lord, but yes, it was that was one of our key points. A, it's not our service specification. We're doing what we're being told to do. And B, that which we are being criticised for is the making of a referral to other NHS bodies. My Lord, for those and other reasons, we had contended, particularly and then obviously the classic JR point that my Lord has mentioned once, which is the criticism of what we did was based on an assertion that the actions of our clinicians were in some way unlawful, when that's not apt for judicial review.
Well, I only raise it because the more, speaking personally, I dipped into the bundles, and the great interest that this case has generated has led me to fear that there may be a sense out there that this court is concerned to decide whether this treatment is a good idea or a bad idea. And I hope that everyone understands that that is not what these judicial review proceedings or this appeal is about.
Well, my Lord, that's perhaps one of the reasons why I showed the court Justice Parker in Gillick, who, although wasn't upheld, made the prescient remarks which we say have direct application here, which is however strongly opinions differ, the question for the court is the law.
Yes, well, that observation was precisely in accord with what the House of Lords did.
Precisely, my Lord, and we say the same here, that the question is Family Law Reform Act, Gillick, the Law Society case, frankly, is a complete answer to the entirety of this litigation. Lord, turning then to the second cluster of grounds, and those are the approach to the evidence and the findings of fact. And just for my Lord's note, to make it clear that this was all clearly in play before the court below, just for your note, you can see it from our skeleton below, which is in the core bundle at page 617. So in terms of the approach to the evidence, it should not have admitted evidence without an application and determining that application.
Expert evidence.
Expert evidence, yes. And if one looks at that expert evidence, if they had applied the rules of evidence to it, in our submission, they would have almost certainly rejected it for a number of reasons. Mrs. Justice Carr's reasons in the Law Society case, which is you're not pointing out a technical flaw which is incontrovertible. What you're doing is flagging up a difference of expert opinion. And a difference of expert opinion isn't a matter of judicial review. And therefore, this evidence isn't reasonably required and it doesn't come in. But further, even if more elementarily they had applied the rules of the CPR and the practice direction, the court should have said no CV, no statement of understanding duty to the court. And indeed, we say a number of places that evidence on its face is clearly partisan. For example, one of those of whom reliance is placed is Professor Lieven, who says he thinks the W path is completely wrong, and in relation to that, he considers the court to be his forum of last resort. And so that is the purpose of Professor Lieven. We say this court is not the place for an American professor to ventilate his criticism of international clinical guidelines. And it is not his forum of last resort. And so, if one imagines the position,
I mean, Ms. Myers, even more fundamentally than that, the judicial review here is not of the specification or the international clinical guidelines. So we can't engage in a debate with those guidelines, even if my lord were wrong, and we should, because that's not what it is. And I mean, I have in mind, and probably it's a boring thing to say, but the only live ground for judicial review is to the effect that Tavistock's practice of accepting the consent of children under 16 to puberty blockers as informed consent was unlawful because, on a proper interpretation of Gillick and Montgomery, those children don't have sufficient maturity to make such a decision. And that would involve our putting ourselves in the place of the doctors, as you have submitted. But that's all that's before us, not the quality of the specification, which, as you say, you're bound by. And it's not judicially reviewed. It's not even attempted to be at this stage.
exactly. So, if one imagines the position of the court, had it properly dealt with all of this evidence from the respondents, it should properly have not admitted it and made it clear that it was not admitted. And in that case, it would have had no evidential basis on which to make the findings it relied upon to justify the carves out from Gillick and the Family Law Reform Act. So to give you examples, reflected in the phraseology of paragraph 138, it was contended by the respondents that puberty blockers and process hormones are simply one part. But that is directly contradicted by the evidence of the clinicians who are treating. And it's also directly contradicted by the service specification, so the specification that guides the work of those clinicians. One example. The other one of the other findings of fact relied upon by the court to justify its carve-out is this finding that the treatment was experimental. Now, in one sense, the court gave the word experimental its own definition and then applied it. But my lord, again, if one goes back, for example, to the evidence of Professor Butler, the evidence of Dr. Alvey, highly experienced, highly respected clinicians, explain why it is not proper to call this treatment experimental. And again, how on earth could this court, the court below, how on earth could the court below have reached that conclusion? Well, either by a priori reasoning, which we say it would be A, wrong, and B, it's simply not in a position to engage in because it's not posed at conditions. But secondly, by finding, by implication, that what was said by Professor Butler, Dr. Alvey, Dr. Carmichael was incorrect. And that's simply not open in such circumstances to a court concerned with judicial review. And now, Lords, I've sketched out the big picture in relation to that, but there's another strand I've asked to pick up, which is the fact that the court, both in its refusal of the grant of permission to appeal, but also in its judgment, does a curious thing of disavowing any reliance on the evidence. And there are multiple examples of that. I'm not going to take you to them, but just give you the paragraph numbers: 9, 70, 74, 77, 78.
Sorry, could you do that a little more slowly?
9, 70, 74, 77, and 78. So the court repeatedly says, and in well, we're not relying on this evidence. We say if a court isn't relying on something, why cite it? But we say, in fact, if one examines the reasoning of the court, it clearly was relying on it. So just to give you an example, you turn to paragraph 45 of the judgment, which is at page 83 of the binding. What the court there says is relevant to the evidence of consent is the evidence of Professor Scott. So it is expressly, that is my reading of the sentence, relying upon evidence advanced by the respondent saying it's relevant. And then it cites it in that paragraph and in the following paragraph. Now, Professor Scott doesn't provide the court with a CV. She gives no indication that she has any expertise in the assessment of the understanding of children and young persons so that they are able to give consent to medical treatment.
Well, and we've seen your skeleton where you've done a quick search and discovered what you can, but that illuminates the problem.
But also, my lord, she gives evidence which in itself makes a leap of logic which is impermissible. So if you have a look at paragraph 46 of the judgment, it cites her paragraph 11. And she starts off saying, and it's the fourth line down, it is very possible for an adolescent to be unable to fully grasp the implications of puberty blocking treatment. Well, that's unacceptable. But then she says, all the evidence we have suggests that the decisions required to engage in this treatment are not, the skills required, to engage in this treatment are not yet acquired as skills. So she goes from a sentence which is unexceptional to a far more trenchant and exclusionary position without any explanation of how she goes from one position to the next. But the court says that this evidence is relevant to its decision. So, the Lord has used observed, there are a host of examples of the way in which this court, the court below relied on this problematic evidence. I'm concerned that I'm getting perilously close to 3 o'clock. And so I'm not going to labour them, but I'm saying if I invite you to go back, for example, to the elements of paragraph 138, those elements one can see relate to findings which were not supported by the evidence of the appellants, and further that the very power to make that declaration was asserted to rely upon evidence, again, that was not advanced by the appellant. Now, my lord, obviously our final ground relates to the Human Rights Act. We've seen the cautious way in which we put that. We don't, of course, claim our personal grant in that regard, but we adopt the submissions that are made by others, such as the Association of choice for children and liberty in relation to the rights-based context. And of course, you're also seeing this morning, I showed you Mr. Justice Silver indicating that the law of children's rights reinforced Gillick. And so the common law had given us Gillick, and all that children's rights did in one sense was provide additional fortification for that. If I turn then to what we seek as an outcome of this hearing, we seek a return to the established legal position. We'd ask this court to quash the declaration, and we would ask this court to indicate that the guidance given by the court below was improper and or is of no longer of application. Because the position will then be that decisions about the treatment of children and young people who are experiencing gender dysphoria and seek treatment of puberty blockers will be governed by the Family Law Reform Act, Gillick, AB, the regulators in the form of NHS England, the Service Specification and the CAS Review, the CQC, the GMC and HCPC, or whichever active and bound regulator one might be concerned with. And we say that that established system, and an extensive and powerful one, as we can see, because it's been brought to bear on the circumstance of this case in a number of ways, ought to be left in place, and it's not appropriate for the court to venture further into that arena. There's just one other point of evidence I've been asked to draw to the attention of the court, and it was in, perhaps I can just give you the note, the third witness statement of Dr. Carmichael, and it just touches again on this issue of fertility and the child's understanding of any impact on its fertility going forward. And she explains that one of the benefits of puberty blockers is that it allows for longer and more profound conversations about the impact on fertility of possible subsequent treatments. And that is in the supplementary bundle, page 244, paragraphs 15 to 19, particularly paragraph 19. May I just turn my back? I've got nothing else, thank you.
Thank you very much, Ms. Morris. Mr. Hyam.
My Lords and my Lady, on behalf of the respondent, we say at once that it's right to observe that the issue in the judicial review proceedings was the lawfulness of the practice or policy of the Tavistock prescribing puberty blockers to children, particularly children under the age of 16. The basis of the case, from the factual evidence recited in the judgment, was that some children, 3 who were 10, I think then it's 12 who were between 11 and 12, and then another 12 or 13 who were 13, totaling 26, were deemed to be, on the statistical evidence produced by the Tavistock, were deemed by the Tavistock to be giving valid consent in law to the treatment that they were receiving. That was a highly concerning matter for reasons which were elaborated in the claim form, because it appeared that, as a matter of law, valid consent was not being given because the child in question did not and could not have sufficient understanding to take the decision in question. When the matter reached the point of judgment, the court rightly identified at paragraph 133 of the judgment, the issue as being, can a child or young person under the age of 16 achieve Gillick competence in respect of the decision to take puberty blockers for gender dysphoria? We say the court rightly answered that question in the judgment, and it's epitomised at the end of paragraph 151. The core paragraph about which the declaration is concerned is paragraph 138. Now,
Well, the answer it gave was yes.
Yes.
Yeah.
That's correct. But the declaration that was made
Yes.
is at 138 in terms
Right.
of the order. Sort of.
But if one starts with the principal issue before this court is in some ways a narrow one, can a child or young person under the age of 16 achieve Gillick competence? Well, the court answered that question in the affirmative.
Yes, it is possible.
It is possible.
It is possible that they can. However, very much as in, we say, as in action, as in Gillick itself, the child would have to have full understanding of certain factors in order for that consent to be valid in law. And all the court is doing is saying that in terms. And it is an unexceptionable course that the court took, and it's correct, we say, for reasons I'll try and elaborate. In understanding that decision, the court, and in making the declaration it did, the court was striking a balance between three strands of public interest. The first is the autonomy of a child. The second is the protection of the best interests of vulnerable children, of whom undoubtedly those seeking seeking puberty blocking treatment because they're suffering from gender dysphoria undoubtedly are. And a third strand, respecting the rights of the child and also the rights of others. This is essentially, in brackets, a human rights regard, but it doesn't need to be dressed up in human rights terms. But including someone like the child's parents, of course, Mrs. A, whose facts are summarised in the judgment of paragraph 89, is a person likely to be affected by the treatment or the practice or the policy of the Tavistock, which is why she had standing to bring the claim, which is why she was a claimant in the proceedings. Now, we say the way that the court approached the issue before it was to apply the flexible Gillick principle established by the House of Lords in that case, and is the correct balance. The declaration of law as to what is required for competence to consent, see paragraph 1 of the order and in the court bundle of paragraph 70, is actually accurately stated, we say, at paragraph 138, and cannot be faulted for all the criticism that I have just heard from Ms. Morris. The fact is, all of those subheadings are based on the defendant's own evidence, not on a resolution of conflicted evidence, all on the defendant's own evidence, and indeed on their own standard operating procedure for taking consent. Which I'll show you in a moment. The guidance which the court then proceeded to give as a matter of discretion is at paragraph 145 and was, we say, entirely apposite, read against the context of the background evidence about which the court had heard and the submissions had been made, and the very serious concerns that are raised about the nature of this treatment and its experimental nature. Now, I know that experimental phrase is in dispute, but it's quite clear, we say, from the way that the court defines the use of that term, it is a clear reference to the absence of clear evidence of clinical effectiveness. And there is ample evidence, nothing to do with the claimant's evidence or experts, ample evidence from the defendant itself, including the early intervention study cited in the judgment, of limited clinical effectiveness of the treatment. Now, when we approach this question, or the overall case, we say that they properly understood and applied Gillick. We do not accept that there is a distinction to be drawn between the Gillick case, where there is tension between parent and child, and our case, where it is said, in the case of treatment under the operating procedure, there is no tension. That is not a valid distinction in law to make in relation to the question whether the child can give consent. And in order just to understand that point in the round, it's important to remember the context in which this case was determined, because the claim was brought in respect of the practice of the Tavistock by reference to its service specification. And it was quite clear from that service specification that the consent of the child was a necessary prerequisite to treatment. It was part of the eligibility criteria for treatment, and that is acknowledged in the judgment. It is part of the WPATH standards of care. And so the court's focus, and you see how they dealt with it, they didn't need to deal with parental consent because they were told, and we were told in the clearest of terms in the pre-action correspondence that there was in this case. And if I could just give you the reference for that. Part of it is quoted in the judgment itself. But the pre-action reply at page, my reference is 088 of the unagreed bundle, at paragraph 73. I think paragraph 36 is reproduced in the judgment. It makes the same point. Parental responsibility is never relied upon in respect of consent to treatment with hormone blockers, as children who are not competent to provide consent are not eligible for treatment with the hormone blockers. Now, that eligibility criterion, both in the standard operating procedure and in the WPATH standards of care, can I give you the reference for that? If we've got the WPATH standards of care in our supplemental bundle, the reference is at page 20. The internal of the so it's
Did you say internal 25? In which case I think that's page 31.
Is using the bold numbers at the bottom right-hand corner, 25.
Oh, right.
So the numbers of the bundle, internal 19 in softer type. Fourth bullet point, criteria for puberty-suppressing hormone. The adolescent has given informed consent, and particularly when the adolescent does not reach the age of medical consent, the parents or other caretakers or guardians. So both are required under the WPATH standards of care. As we say, in supporting the divisional court's conclusion, we say they understood, and of course in that case, the issue before the court is whether a doctor could lawfully prescribe contraception for a girl under 16 years without the consent of the parents. You've seen the references to that already. And the court's conclusion, or the House of Lords' conclusion, was that the parental right yields to the child's right to make his own decisions when he reaches a, and I emphasise that word, sufficient understanding. And that's at page 186B. We've messed with that in due course. The phrase at 189A of the same judgment is a sufficient understanding and intelligence to enable him or her to understand fully what is proposed. And it was that focus that, and the concept of full understanding of what is proposed, that is essential, or was essential, to the question the court had to answer. Now, during the course of her submissions, Miss Morris appeared to say, and I may have misheard, that questions of understanding were not part of consent. I said it plainly are part of the consent process. The child must have full understanding of the treatment proposed, its risks and benefits. It must be able to weigh that information in the balance and reach an informed choice. If the contrary is being argued, we say it is untenable and does not fit with either Gillick or W or any of the cases that look at the competence. Now, our submission is that by applying the proper principle of law, which is if but only if sufficient understanding is achieved, then valid consent is obtained, the court, using that as their model, asked the question of puberty blockers: is valid consent in law obtained in circumstances of its prescription or referral for prescription by the Tavistock? And their answer is only, if but only if, the items in paragraph 138 are fully understood by the child in question. There is absolutely nothing wrong, we say, with the court expressing that view. They not only are entitled to on the defendant's evidence, which is plainly what they relied upon, but it is similar to that which Mr. Justice Silver did in Axon, and we've been shown paragraph 154, and in due course I may take you to that decision. But it reflects the point made in Gillick that, and indeed expressed by Lord Scarman at 189C to D, that much has to be understood by a child under 16 if he or she is to have capacity in law. The 138 and subparagraphs to it, the Roman numeral subparagraphs, are an expression of that concept in the factual matrix and context with which we are considering. And in particular, as again Lord Scarman uses the phrase, she must have sufficient maturity to understand what is involved. And right at the heart of what the court was concerned about, and they give an example relating to sexual function and fertility, was how can it be said that children 10, 11, 12 have any proper conception of what sexual function is like when they necessarily have no proper experience of that, not ruling out the exceptional case that there might be, and then again it's not a black and white, except as more the Lord Chief Justice has indicated, the primary answer is yes, but subject to the paragraph 138, if but only if these are achieved for valid consent. And it was clear again from both Axon and Gillick that a number of factors are necessary to be understood before the child can give effective consent in law. That's Scarman and it's Silver in Axon. How then, we say, is it wrong in law for this court to say, given the question is what in law is necessary to achieve capacity for puberty blocking treatment, with an answer which is, in principle, a child can consent to treatment, but it will only be in circumstances where the following matters are fully understood by the child. That is an entirely orthodox, we say, application of Gillick to the particular facts of the case.
Mr. Ham, can I ask you a question? If, as you say, paragraph 138 is taken entirely from the respondent's own evidence and service specification, why is it necessary for the court to set it out when, by its very nature, it only identifies some parts of the elements in the service specification? specification, and I think you're accepting that the service specification is the approach the clinicians must adopt.
Well, it's slightly more nuanced than that for two reasons. Firstly, the service specification, and we can look at it in detail, but makes clear that it will be subject to whatever standard operating procedure and spectrum of informed consent is going to be run by the Tavistock. The Tavistock themselves produce a standard operating procedure which indicates certain matters that must be satisfied for the child to be ready, what it describes as readiness indicators under the rubric of informed consent. Now, our point, coming back, is to the point I think you're making to me, which is why, if it's in the service specification, is it necessary for the court, or appropriate for the court, to define the salient features of what consent in law requires? And the answer is because the evidence before the court, the defendant's own evidence, suggests that there was real concern as to how and whether that approach could be being applied rigorously by the Tavistock. Thus, you see in the judgment the observation that the impression that the judges got from reading the evidence of Professor Butler, that no child had ever been refused on grounds of competence treatment. What there was a reiteration of information. That's, I think, I'll give you a paragraph reference, but that's something that's said in the judgment. The fact that the submission that was made below, and the submission I repeat to this court, the fact that it was being said that 3 10-year-old children understood the salient facts as defined in paragraph 38 in order to commence puberty blockers with all its unknown effects, with all the consequences of that treatment, was, we said below, a fairy tale. And we maintain that.
Yes, but there's no finding to that effect. On the contrary, the court says it can't make individual findings.
Agreed.
And following from my Lord's intervention, it sounds to me as if what this submission amounts to is that the policy of the appellants set out in the documents that you've referred to is entirely lawful. The concern is that there have been instances where the policy has not been followed. And we've got something, it's slightly unusual in judicial review because you have to establish an illegality before you get relief. And if I've understood your submission, it's that the court has really distilled in paragraph 138 the appellant's own criteria, or at least some of them.
Yes.
And thus it must be founded on the premise that the appellant's criteria are lawful. In other words, the policy is lawful. If your complaint is that the policy has been applied unlawfully, in fact, in some cases, I think Gillick makes clear that's not what judicial review is about.
My Lord, the judicial review is of the legality of their practice. We can look at their standard operating procedure and what is required. It's not defined with the precision of paragraph 138 to make clear what the law is, which is what is absent and why such a declaration was necessary.
I'm sorry to press you on this because I'm just troubled by the use of the word practice. What exactly is it that is encompassed within that simple word for the purposes of this judicial review challenge?
The practice of referring for puberty blockers as set out by reference to their own operating procedure, which fails adequately, which is why section paragraph 138 is necessary, to define the salient facts that need to be understood for valid consent in law to be given.
I'm saying for my purpose, you've got to say that a bit more slowly because I need to get it down precisely.
I'll try and say it again, but in the same way. But the
practice of referring children for puberty blockers according to
their service specification, standard operating procedures is unlawful.
You said which fails adequately to
Because it fails
identify.
adequately to articulate or express the salient factors, not facts, factors,
Yes.
which are necessary for valid consent in law to be given.
So I am sorry to press you on this, because this sounds to me as an exercise in trying to get the court to redraft a policy document, a standard operating procedure, a service specification, when you're not submitting that there's anything unlawful about them. It's that they could go further and add some more detail.
No, I am saying that they are. I'm saying they're insufficiently clear, and the result is an unlawful prescription of drugs because they fail to ensure valid consent is given by the child.
And that's the legal standard you submit is the correct one, that the documents have to ensure valid consent in all cases. So independently of whatever the doctors and clinicians might be doing, independently of the second level, which we'll be hearing about in due course from Mr. McKendrick and Mr. Skinner, I don't doubt. That's the legal standard, that the documents must ensure. Because that's quite a long way beyond any authority that I'm aware of, I'm bound to say.
They must not give rise to substantial risk of unlawfulness. And one finds that proposition, for example, from Miller and College of Policing, which is but that's if the practice or process is inadequate to obtain validly informed consent, or there's a substantial risk that it's inadequate to obtain validly informed consent, then that practice or procedure will be unlawful.
So it's a substantial risk test. Is that consistent with what was said in Gillick?
Yes, it is. Because what Gillick is explaining is that there must be full understanding. I mean, if one takes, I said I'll return to it, I'll do that in a minute, that the key paragraph, it's in your, it's the first tab, I think, of the first bundle of the statute. May I just simply go straight to internal page 189, that's C2E.
Which judgment is that?
Sorry, the judgment of the House of Lords in Gillick. That's judgment of Lords.
Which of their lordships? Which of their lordships?
Which of his lordships?
Lord
Lord Scarman.
Lord Scarman, sorry. If one able to pick up at the bottom of page 188, just to give what I'm going to refer to as the context, in the light of the foregoing, I would hold that as a matter of law, the parental right to determine whether or not their minor child below the age of 16 will have medical treatment given when the child achieves sufficient understanding and intelligence to enable him or her to understand fully what is proposed. It will be a question of fact whether the child seeking advice has sufficient understanding of what is involved to be able to valid consent in law. And then C to E, when applying these conclusions to contraceptive advice and treatment, it has to be borne in mind that there is much that has to be understood by a girl under the age of 16 if she's to have the capacity to consent to treatment. It's not enough that she should understand the nature of the advice which she's been given. She must also have a sufficient maturity to understand what is involved. moral and family questions, especially a relationship with her parents, long-term problems associated with the emotional impact of pregnancy and its termination, and there are risks to health of sexual intercourse. At her age, risks with contraception may diminish but can't eliminate. It follows that a doctor will have to satisfy himself that she is able to appraise these factors before he can safely proceed on the basis that she has, at law, capacity to consent. We say exactly the same approach is being adopted by this when approaching puberty problems. It's identifying that much needs to be understood. It's identifying that there must be sufficient maturity to understand it. It's identifying the nature of the issues that may need to be understood, and essentially saying that those are matters that must fully be understood if there's to be effective consent at all.
Maybe if I could just put the point down now, Mr. Hyman, you can reflect on it overnight. I don't want to put you on the spot at the moment. Lord Scarman, at page 181, internal letter F, identified the tests to be applied when considering policy. He said it's only if the guidance permits or encourages unlawful conduct in the provision of contraceptive services and so forth. The question, therefore, for the House is, can a doctor, in any circumstances, lawfully prescribe contraception for a girl under 16 without the knowledge or consent of the parent? And so it might be thought that he was proposing a binary question, as it is called now. I suppose in those days they would have used that language. And although I haven't immediately got it in my head, the equivalent passage in Lord Fraser's judgment, he says something similar. Lord Bridge agreed with both of them, and the two dissenters didn't dissent from that approach to policy. So can I leave that with you for...
May I revert to that, perhaps in the morning, but I do understand the point, the difference between a binary approach and one that requires, as we say, something more than that, and perhaps relying on the first sentence of the paragraph as well. May I just sidestep now, just to deal with the expert evidence point, put that in context, because I feel that I ought to respond to that now, and if I can do so neatly and efficiently, that would be useful. There are 6 points I'd like to make about the expert evidence issue, and I'm aware that it was raised at some point so far. The first point is this. We filed a judicial review grounds of claim, and the accompanying was evidence from, amongst others, as well as the claimants, Mr. Biggs, Paul Cruz, and attached to the evidence of Mrs. A was the article by Carl Hennigan, editor of the BNJ and professor at Oxford. That no issue was taken about that evidence, and it would have been unsurprising if it were. The defendant responded to the claim, not making an issue of that. When we filed our reply, we filed further evidence, and you can see from the dates in the index, they include Neil Evans, Stephen Levine, Professor Biggs, Sophie Scott, John Whitehall, Professor Gilbert, and Professor Jean Feeder. An objection was taken, and we dealt with that, or responded to that, in our reply skeleton at Paul Bundle 620. Under particular paragraph 3, we raised, we noted the point that they'd made in their skeleton, and we referred to the order made by Mr. Justice Lewis as he then was in paragraph 3, and explained that we've not made an application to rely on expert evidence for its other evidence in reply because we did not consider that the evidence submitted as a kind would ordinarily require an application for permission under CPR Part 35, and we gave reasons, and the analogy to paragraph 5 was the lawfulness of the defendant's practice of prescribing hormone blockers, in particular whether informed consent can be given by children as young as 9 years old for such treatment. Clearly the court needs to be informed about the context to adjudicate if it's not the case where the court is being asked to analyse the evidence of the experts and reach conclusive findings in relation to disputed issues. Rather it is to inform the court. It's not a case like the Law Society and so on. And we then underline the point by reference to the fact that they themselves serve evidence from Dr. Carmichael, Professor Tavistock, but also Dr. Annalise de Vries, a child and adolescent psychiatrist and founding member of EPA, as well as Dr. Alvey. There the matter lay, and the most that happened orally was a reference to flagging the issue. I don't think it's being said that any formal point was taken orally by the appellant. In the judgment, and this is my 5th point, at paragraph 70 of the judgment, the court then explain what they were doing, where they say, and this is the reference for this is page 90 of the core bundle and internal paragraph 70. It is not, however, the court's role to judge the weight to be given to various different experts in a judicial review. In our view, more important is the evidence from the defendant and the evidence base it relies upon for the use of PB. So squarely focusing on the defendant's evidence in the case, and then acknowledges, or from the lack of a firm evidence base for their uses from the very limited published material, a reference to Paul Jenkins, and then their own, this is the defendant's early evaluation paper on the early intervention study is mentioned at 73, and its conclusions reported, the court giving the emboldening in the indented paragraph of paragraph 73, and Ms. Morris saying it's not for this court to determine clinical disagreements between experts about efficacy. We agree, and they didn't report to do so. That is a matter for the relevant NHS bodies. However, the degree to which the treatment is experimental has as yet an unknown impact does go to the critical issue of whether a young person can have sufficient understanding of the risks and benefits to be able lawfully to consent to that treatment. And we say that is entirely justifiable reasons. And then the further document to look at briefly is the reasons for refusal of permission.
So just to be clear, Mr. Holmes, that sentence at the end of paragraph 74 is directly rebutting what they have recorded at 70 as being the view of the respondents. I mean, you say it's for a good reason, but it is in fact rebutting the view of Professor Butler that the factor doesn't render it experimental. And they say, well, its experimental nature is important. So it's not, by this stage, acting on the evidence of the respondent, but on some other evidence.
Well, my Lord, in respect, it is acting on the respondent, because what it's doing is it's saying there is limited evidence of clinical efficacy on the defendant's own evidence.
But there's quite a different thing, I'm afraid, isn't it? Say something is experimental and to say there's limited evidence of clinical efficacy. established treatment. I think aspirins, there limited evidence of what aspirins do, but it's a very well established and not experimental any longer treatment.
Well, that's not the only aspect in which it's experimental. There is a dispute, which is an issue where the court and Professor Butler are clearly at odds, but the court is right and entitled to do that, and that's in relation to saying that because the drug is used for precocious puberty, one can read that across as evidence for its use in gender dysphoria. And the court quite correctly says they're quite different. And you only need to stop to think about it to realise why. One is to stop precocious puberty, which will then recommence at the age appropriate. Whereas what puberty blockers do is they stop pubertal development at its appropriate age with unknown consequences. I mean, nobody knows, that is the evidence, nobody knows what the consequences of stopping puberty for a child are for 3, 4, 5 years. Psychologically, it may be said that physically that is reversible, whether the evidence of any reversibility or indeed any person stopping a blocker, for instance, to undergo fertility treatment, and thus, in a classic child's case, it would mean going to a position where you've agreed to stop the development of your normal genitalia, and you take drugs which have the effect of shrinking them, and then for the purpose of fertility preservation, you stop taking the drugs, develop, say, for example, an Adam's apple if you're a man, or if you're a woman, growing breasts, in order to freeze eggs. I mean, there's no evidence to suggest that that was in any sense in any of the documents that that's what happened. So it is unknown what the consequences are. And so to use the phrase experimental in that context is entirely just. Can I just give another example just while we're on experimental? Carl Hennigan, as I mentioned, was not one of the experts about whom complaint is made partisan or anything like that, not least because of his distinguished status. He appears at 673 of the supplemental bundle. This is an article published by him posted on the 25th of February 670. You'll see from the end that he's the editor-in-chief of the BMJ and professor at the University of Oxford.
So this starts on 670, does it?
670.
Yeah.
670. And his conclusions are set out at 674. Significant problems with how the evidence for gender-affirming cross-sex hormone is being collected and analysed that prevents definitive conclusions to be drawn. Simple puberty blockers evidence is limited by small sample sizes. Next paragraph, archive of disease of childhood, letter referred to treatment of momentous step in the dark, three main concerns. Developmental limbo without secondary sexual characteristics that might consolidate gender identity. Uses like to threaten the maturation of the adolescent mind. Puberty blockers are being used in the context of profound scientific ignorance. The developments of these interventions should therefore occur in the context of research and treatments for under 18 gender dysphoria children as remain largely experimental. There are a large number of unanswered questions that include the age of start, reversibility, adverse events, and so on. And last sentence, the current evidence base does not support informed decision making in safe practice in children. That's the context. Now, I said I'd turn to what the court themselves said their reasons for refusal, and they do that on page, and it's pages 71 to 72 of the core bundle. are two grounds which they're differently ordered now, but there are two grounds where this issue arose. The first is ground 2, where the answer the court gave was the divisional court did not seek to resolve disputes between experts about the efficacy of a treatment. The court summarised the extent of current knowledge of the consequences and the very limited evidence of its efficacy, see para 134, as part of its consideration of what information is held.
I'm lost, Mr. Hyams. Where are you?
Oh, sorry. I'm not there.
Are you in the judgment?
No, I'm in the order made consequent on the judgment
Right.
at page 71 of the core bundle.
Okay, thank you.
I'm sorry, I thought. Now just pause for a moment to make sure.
So this is the reasons for refusing permission to appeal.
Refusal of permission.
Yeah.
First of all, ground 2 I'm referring to. And then, if I may refer also to, on the next page, page 72, ground 9, where it said the defendant complains about the absence of a ruling on evidence adduced by the claimants. First, there is nothing to indicate that the error complained of affects the judgment in any material way. Secondly, the evidence was not used as a means of determining the issues in the case. It was used, as was the defendant's evidence, as a means of understanding the background to the case, is what they say. I wonder if I could, if just before moving on to another aspect about the understanding the court's expression of the treatment as significant and life-changing, a phrase that itself is found in the operating procedure. May I just go to accent, which is in tab 8 of our
Page 24. We've taken
page
to
212
yeah.
of core bundle, page 212.
So this is
And as has already been observed, this is a case that looks at Gillick in the context of abortion. And paragraph 13 of the judgment, if I can go to recitation of various passages, as you can see, at paragraph 12 of the judgment, computer page 218, internal page 545 is what I'm at. And at the bottom of the page at G, an agreement by Lord Bridge with the speeches, and then a list of points which emerge from the speeches of the majority are listed out, including at 5, Roman 5 on page 546 at between F and G. The judge emphasises in italics much understood and so on as a key aspect of that decision. In the later reasoning of the case, at paragraph 85 through to 90, we then have the analysis. You were taken to some of this already, but if I could pick up at page 569, internal, computer 242, paragraph of the judgment 85, subheading, what did the Gillick case decide about the need for parental notification on sexual matters? The starting point to resolve this issue must he considered the basis on which the appellate committee reached their decision in Gillick. And as I've seen, that's been summarised to a large extent at 13. I will not repeat the pertinent points in the reasoning of the majority, which I've set out. And then the speeches of Lord Fraser, Scarman and Lord Bridge not indicate or suggest that their conclusions depend in any way on the nature of the treatment proposed, because the approach is a general application to all forms of medical advice and treatment, and in general italicised terms the reasons why parental knowledge might be required. And then this at 87. There does not appear to be any reason why that approach should not also apply to other proposed treatment and advice, as the litmus test for determining if any treatment and advice can be given without parental knowledge will also be whether the young person, in Lord Scarman's words in the Gillick case, achieves sufficient understanding. So in addition to the general approach, the litmus test for the questioning of all will also be achieving a sufficient understanding, and then that's reproduced. And then there's the point about Mr. Havers emphasising that abortion raised complex issues and so on at paragraph 88, and emphasising, again, at the top of page 570 of the report, computer page 243, within paragraph 89 at A, as I pointed out in paragraph 13, this requirement means that she will have to appreciate all aspects of the advice, because Lord Scarman then explained what he meant by sufficient understanding, and then that is repeated. And then at 90, there's no reason why this approach cannot be adapted so that a girl could only be considered to have understood the advice if she understands properly what is involved. This would constitute a high threshold, and many young girls would be unable to satisfy the medical professional that they fully understood all the implications of the options open to them. Pausing there, that really is not very different from what is happening in this case. It's almost identical. These requirements would be underpinned by two matters, which the first is that the sanction for medical professionals is explained by Lord Fraser and professional guidelines, and the second matter is that a medical professional is required to take into account all aspects of the young person's health and so on. And the final sentence at F, in summary, there's no reason why Lord Fraser's guidelines and Lord Scarman's criteria should not be adapted and applied to advice and treatment for abortion, even though abortion raises, as I've explained, more serious and more complex issues than contraception. I conclude that they should be adapted, and I set out at one point for how that should be done. So, the court focuses on a treatment which hasn't been examined by the court before. It's more complex and raises more serious issues. Its approach is to recognise that full and sufficient understanding is a prerequisite of valid consent in law, and then at 154 of the same decision, recasts the Fraser guideline at paragraph 154. In particular, this is computer 259, internal page numbering of authority 586, at paragraph 154, between F and G, but with the preamble which reads, this leads to the conclusion that the medical profession is entitled to provide medical advice and treatment on sexual matters without the parent's knowledge or consent, provided he or she is satisfied with the following matters. 1, that the young person, though under 16, understands all italicized aspects of the advice, and in the light of Lord Scarman's comments, must have full understanding and sufficient maturity to understand what is involved. That understanding includes all relevant matters and is not limited to family moral aspects as well as possible adverse outcomes. So there we say there is the court in action, taking Gillick, taking the principle established about full and sufficient understanding, applying it to the facts under consideration, and adapting a guideline or criteria which stipulates that all matters must be taken into account and refers specifically to the need to have full and sufficient maturity for understanding. And so our case again is that there is nothing in law wrong with what the court does, paragraph 148. My Lord, at we also say that the court was right, and it clearly is relevant to the exercise of its discretion, whether or not to give guidance and also to stipulate the matters, salient facts that are necessary to be taken into account before valid consent can be given, to stipulate or to say that the decision was significant and life-changing, and, relying on S, that there's a greater onus to ensure that the child understands and weighs the relevant information. And again, in the S case, and I think if I may, I'll try and deal with that briefly now. In the S case, which is referred to, it's in the core bundle. So the core bundle of authorities, please, page 383. And this case clearly influenced the court, not least because it was just a. You may as well know that this was an authority that the court itself suggested it would like submissions from the parties upon. The facts concern a mother under the age of 16 to agree to a baby being accommodated under the Children Act, and we've looked at that to some extent so far. If I could just ask you to look, please, at computer page 390, paragraph of the judgment 14, internal pagination 184, and a summary of by what test does the court assess generally the competence of a child as a decision maker. And we begin with, obviously, Gillick, and Lord Fraser is reproduced, and we simply note Mr. Justice Cobb's italicisation of sufficiently effective consent and sufficient understanding and intelligence of Lord Scarman, and the italicisation of the next paragraph, clearly pertinent to what Mr. Justice Cobb was deciding, and the focus being on sufficient understanding and maturity. At C, in applying the Gillick test in the context of determining the competence of a child to make decisions, I regard as appropriate and indeed helpful to read across and borrow from the relevant concepts. Now, just pausing there, we've seen that Mr. Justice or Justice Mumby in his X decision has queried the question of the read across. But importantly, from our purpose, if we look at 17, whatever the argument may be about read across, paragraph 17, the following principles relevant to decision making can usefully be applied. The determinations of a child's competence must be decision child specific. Well, there's no issue about that. And matters raised at Roman 2 at F and Roman 3 at G. And then please note that at paragraph 80, the approach outlined at 14 to 17 above is advanced by the local authority in this case. They're not wholeheartedly supported on behalf of S. That said, it is agreed by all parties that in order to be satisfied that a child is able to make a Gillick competent decision, i.e. has sufficient understanding and intelligence to enable him or her to understand fully what is proposed, the child should be of sufficient intelligence and maturity to 1. Understand the nature and implications of the decision and the process of implementing that decision. 2. Understand the implications of not pursuing it. 3. Retain the information long enough to take place. 4. Weigh up the information and arrive at a decision. And 5. Communicate that decision as core elements of what informed consent means at common law. Nothing to do with the mental capacity, we say. And therefore, this is another example of salient factors being identified by the court, and they are identified at paragraph 62, and you've been taken to it, 62 Roman 7, at computer page 402, internal page 196, paragraph subpara 7, and the salient factors are given. And it said against me that, well, that's different because that's legal advice, whereas what is, whereas this is a case dealing with medical advice. We say that's not a proper distinction that can be drawn, because it's quite clear, we say, from both Axon and Gillick itself, that the court is saying that the child must be able to understand, and the relevant matters have been italicized in those paragraphs I just showed, fully what is proposed, and the aspects of what is being done, the nature of the treatment and its consequences. And clearly, those matters are capable of forming a declaration. Indeed, it was quite orthodox, we say, to do that which the court did.
Well, the broad statements of principle that we see here, which are lifted from Gillick, were not an issue, were they? I mean, common ground between everybody.
Right.
So I come back to being puzzled why a declaration is necessary to deal with something that is not an issue.
Because the particularization of that which needed to be understood for valid consent in law was something that the court needed to adjudicate on against the facts and the background facts that were before it, because that was at the heart of the claim that the prescription of puberty blockers to young children was not sufficiently protecting the best interest of rights of children, because the process or procedure did not properly articulate or encapsulate the salient facts that needed to be understood before consent to be given. In the context of the case, it's been identified where the primary argument was no child can, and the court's answer was yes, in principle they can, but only if these matters are satisfied. And it was therefore entirely appropriate and proper for the court so to express itself in order to delineate what needed to be achieved by the doctors in order for informed consent to be done. And the implication is that the approach of the Tavistock, insofar as that those matters were not and had not properly been taken into account, was unlawful or gave rise, as I've said, to a substantial risk of unlawfulness, which is why it was necessary to make the declaration the terms it did.
Mr. Hine, could it be said there is a difference between the quality of the necessary understanding, which is perhaps what the passages you've drawn our attention to deal with in both Gillick and in this case, on the one hand, which is a legal matter, going to the what the doctor has to do as a matter of law, and the matters that factually need to be understood, on the other hand, which is what paragraph 138 could be said to be more directed to, since, as you say, all those matters come out of the service specification.
They can be derived from the evidence of the service specification standard operating procedure. That's the first point. The second point is that my submission is it's not proper to draw a bright line distinction between facts as that need to be understood under paragraph 138 and sufficiency of understanding. There are two parts. A single process, which is understanding fully what is proposed and the likely consequences both of treatment, including not just immediate side effects, but long-term consequences. And the particular focus here, just to try and give it a bit more shape, is, and things that were clearly of particular concern to the court, were questions of fertility and sexual function. And you mentioned those specifically. And their thought process, if I may be permitted to try and examine or try and explain what I consider their thought process is likely to be is along these lines. It's clear that the taking of puberty blockers is very likely, in many cases, Professor Butler's cases, in at least 80% of cases, to use Anne Deviation's published articles, between 1.9 and 3.5% only did not go on to cross-sex hormones. The commencement of this treatment has these consequences, significant and life-changing and lifelong, a lifetime of medication, a lifetime of perhaps surgical intervention if that's chosen later down the line. Cross-sex hormones very likely to be taken. The child must understand what is involved, the facts. Now, to some extent, as I've said, and if I could take it to you now, rather than the standard operating procedure in relation to informed consent deals with that up to a point. And could we look at that? Because it's an unagreed bundle. It begins at unagreed bundle 053.
Sorry, could you give me the reference again? Unagreed?
Unagreed 053, 53. And this was produced by the defendant's main witness, Polly Carmichael, as the consent procedure operative from January 2020. So it was the new updated version.
So this is in our unagreed bundle, but was it before the court?
It was before the court, yeah.
Yes.
And I'm using if you look at the first page, you can see what it is, version 1, date and so on. And it says what it is, a standard operating, incorporating guidance and documentation in relation to consent for referral to the endocrine liaison clinic. And then a summary of what the gender clinic is about and so on. An appendix, I'm going to skip over 54, 55, and then we have Annex B, guidance for clinicians, at page 056, assessing readiness for referral to endocrinology for hormone blockers. And in terms of readiness core indicators, these are expressions made by the patient and physical or biological development. But it includes the final bullet point of readiness core indicator 1 at page 056. The young person has been assessed by a judicial clinician as Gillick competent to give their consent to the referral to the endocrinologist at the time of these conversations. That is, they've demonstrated sufficient understanding of what the blocker will do, how it works, and its possible side effects, as well as an appreciation of the potential for unknown impacts of blockers and the impacts over a longer time frame. Now, one of the things it does not say, and this is a matter, and yet it is a matter based on the defendant's evidence, is the almost inevitable vast majority of cases going on to cross-sex hormones. It does not say that. But what it does do, under the development mental indicators, it does say things that will affect you. Body discomfort, dysphoria, seems best understood in terms of gender experience. And then the second bullet point, perhaps not relevant. The third bullet point, not. But the next one, there has been discussion of likely future bodily experiences with and without the blocker. And that is a reference to what the future holds. On a narrow view, by reference to the blocker only. On the wider view, including stage 2 cross-sex hormones, as encapsulated in paragraph 138, it includes the consequences of cross-sex hormones and perhaps moving on to surgery as well. And I'm not going to take you to it now, but if you have read the statement of Professor Lee, he deals with the practical reality of, for example, sexual function post-surgery. But it goes on. Indications of body discomfort and so on. And then the next bullet point, there has been some considered discussion of other future possible medical decisions, e.g. surgery, and their bearing on the current decision. And then the next bullet point is about consideration to the growth of adequate penile tissue for later genital surgery if this is sought in adulthood. And then the next, again for assigned females, of halting restoration. And then fertility. Likely impacts on fertility have been discussed recurrently. That only makes sense. And if you read the Endocrinological Society guideline as well, if it is envisaged that there's a likely cross-sex hormone transfer, because that is what produces irreversible fertility. The young person family are aware of the possibility of fertility preservation and NHS pathways for the younger children. Next, discussion with the young person or parents has included the possible impact of the blocker on sexual feelings and function in an age-appropriate way. Now that age-appropriate way is one of the issues which were developed in argument because, and you can see in the conclusions of the judgment where they say in terms, however much information you give, however much recurrent reiteration of the advice and documents, children, certainly some children, are never going to be able at that age to compute or be able to properly understand the implications of what is being advised. And what we say is that what the court has done is said, well, we've seen your standard operating procedure, you're touching it, we need to clarify for you and for all persons who may wish to take what needs to be understood, because if expressed in this way, there is a substantial risk of unlawfulness because the informed consent will not be obtained, whereas expressed in the paragraph 138 way by reference to facts that need to be understood, it's quite clear that the clinicians have to properly weigh up whether the child has those matters. I wanted to take you to that. It may be that it's a convenient for me now to pause till tomorrow. I'm well aware of the point that you want me to take.
Well, and if you're looking overnight at Gillick again, Mr. Hyam, I think it, at least for me, it would be helpful to look at the degree of specificity in the policy that was under review in Gillick, because if I've understood the submission you've just made, it's not that you suggest there is anything positively unlawful in the readiness, developmental indicators and so forth, but the submission is that it's not clear enough, there should be more there. Have I really...
Well, you have understood
yes.
how I put it. I'd like to revisit that over.
Of course.
Certainly that is our point, and that is the explanation for paragraph 138.
I mean, I would like you to explain why it's useful to pull particular factors out when the exercise envisaged in Gillick is a fact-specific one. And just to say whether you say there are other factors that could be relevant in some cases that are not mentioned there.
I fully understand that point, and I'll seek to address that tomorrow morning. My pat response to it is the phraseology of salient facts taken from S, and the court focusing on those points as the ones that are clearly relevant for balance.
Yes, well, we'll look forward to hearing you at 10:30 tomorrow morning.
All rise.